I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a Lawcast series talking about the Florida and federal M&A broker exemption. Following the SEC's lead, effective July 1, 2016, Florida passed a statutory exemption from the broker-dealer registration requirements for entities affecting securities transactions in connection with the sale of equity control of private operating businesses, called an M&A broker. Interestingly, the new Florida statute, together with the SEC M&A broker exemption, may have paved the way for Florida residents to act as an M&A broker in a reverse or forward merger involving OTCQX traded public companies without broker-dealer registration. Florida has historically had stringent broker-dealer registration requirements in connection with the offer and sale of securities. Moreover, Florida does not always mirror the federal registration requirements or exemptions. For example, Florida is one of 5 states that does not have an issuer's exemption from the broker-dealer registration requirements for public offerings. However, in a move helpful to merger and acquisition transactions or M&A transactions in the state, Florida has now passed an M&A broker-dealer exemption and concurrent securities registration exemption for M&A transactions. As I will talk about, the Florida exemption is similar but not identical to the federal exemption. The SEC exemption specifically limited itself to the federal broker-dealer registration requirements and not state law. The sale of securities in Florida is regulated by the Florida Office of Financial Regulation, Division of Securities, and is generally found in the Florida Securities and Investor Protection Act in Chapter 517 of the Florida statutes and corresponding rules adopted under the Florida Administrative Code. Any offer or sale of securities in Florida, which offer or sale is not preempted by federal law, must either be registered or exempted from registration in accordance with the state securities laws. The Florida registration exemptions can be found in Florida statutes section 517.061. All sales of securities in Florida must be made by a properly registered broker-dealer or by someone utilizing an exemption provided by Chapter 517.12 of the Florida statutes. The new M&A offer and sale exemption has been codified by adding a new securities registration exemption to Section 517.061 and a new broker-dealer registration exemption to Section 517.12. From a very high level, the new Florida statute provides an exemption from the broker-dealer registration requirements for brokers that affect M&A transactions with a privately held company that does not involve a public offering of securities and where the company is not a shell company. In the next Lawcast in this series, I will drill down on the specific Florida statutory requirements and provide a comparison to the federal guidance. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.